Hola, ¿cómo están? Buenas tardes. Bienvenidos, bienvenidas. Muchísimas gracias por esperar estos ratitos que estamos esperando que todos pudieran ingresar. Muchas gracias por estar conectados del otro lado. Mi nombre es María Fernanda González, soy la coordinadora del programa internacional de la Facultad de Derecho de la UNR. El programa internacional nació hace ya más de 20 años atrás y hoy tiene como objetivo principal el de poder crear espacios, el de poder generar espacios en donde estudiantes y egresados puedan combinar el derecho con el estudio de un idioma extranjero y en esta oportunidad con el inglés. Hoy vamos a dar inicio a un nuevo ciclo, estamos creando justamente un nuevo espacio enmarcado dentro de la prestigiosa competencia internacional de arbitraje, más popularmente conocida como Bismuth, y, y muchas gracias entonces a todos por estar interesados, por querer ser parte también de esta competencia. Quiero agradecer también a las profesoras María Elena Barbero, a la profesora Leonor Auera Jacquemin por todo el trabajo y el esfuerzo que han puesto desde hace años en esta competencia y también principalmente todo lo que han hecho para la presentación de hoy. Y un gracias enorme a las autoridades de la facultad, a los miembros de la Comisión de Competencias de la FEDER por impulsar y por apoyar este tipo de actividades académicas. Hoy se encuentran presentes la doctora Evelyn Celaya, coordinadora de la Escuela de Graduados, el doctor Augusto Polinari, secretario estudiantil, y el doctor Juan Manuel Pla, secretario de Relaciones Internacionales. Muchas gracias por estar y no sé si ustedes quieren decir también algunas palabras.
Bueno, voy a comenzar yo. Buenas tardes y bienvenidos todos y todas. Como ya me presentó Fer, mi nombre es Evelyn Celaya, trabajo en la gestión de la facultad, en la Escuela de Graduados, pero hoy los acompaño en mi carácter de miembro de la Comisión de Coordinación de Competencias de la facultad. Me acompañan también el doctor Augusto Apolinari, secretario de Asuntos Estudiantiles, y el doctor Juan Manuel Pla, secretario de Relaciones Internacionales, quienes integran conmigo la comisión, que también está integrada por la Secretaría General y la Secretaría Académica. Y ponemos de resalto la comisión porque hoy tenemos como disertante de esta actividad a una docente de nuestra casa de estudios y entrenadora de la competencia Bismuth, la doctora María Elena Barbero, y esta actividad se está realizando en beneficio de dicha competencia, ya que el pago que han realizado ustedes por sus certificados de asistencia a la actividad va a ser destinado a la competencia Bismuth para que puedan afrontar los gastos que demanda la inscripción y la participación de los alumnos en la misma. Así que agradezco a la doctora María Elena Barbero por su labor, no solo como docente de nuestra casa de estudios, sino también como entrenadora, y también por impulsar esta actividad en beneficio. Bueno, también a María Fernanda, nuestra coordinadora del programa internacional, por la gestión en esta actividad, a Fernanda Frola, que siempre nos acompaña en todas las actividades del programa, a Leonor, que nos está acompañando también pese al desfasaje de horario que tenemos, y bueno, brevemente, antes de darle la palabra al doctor Pla, la Comisión de Coordinación de Competencias nació en el año 2022, previo a haber sido durante muchos años solamente un proyecto. Yo he participado durante años en la competencia de arbitraje de inversiones, en 5 ediciones, como entrenadora, y la verdad que siento hoy un inmenso orgullo de que nuestra casa haya logrado conformar una comisión que tiene como fin principal impulsar, incentivar y mantener y consolidar la participación de los equipos en las competencias y fundamentalmente el prestigio que alcanzó nuestra casa a través de la inmensa labor que se lleva a cabo desde los distintos equipos. Así que bueno, muchas gracias a todos por acompañarnos, por estar presente, a quienes han gestionado la actividad por esa labor y le voy a dar la palabra a Juan Manuel, que está ahí conectado. No sé si no lo veo. Ahí está, Juanma, adelante.
Sí, acá estoy, acá estoy. No sé si se me escucha bien. Bueno, buenas tardes a todos y todas. Muy feliz de poder participar en esta ocasión de esta actividad. Felicitaciones al programa nacional, a Fernanda, que viene haciendo un laburo enorme ahí desde el programa. Como recién me presentaban, yo soy secretario de Relaciones Internacionales, pero como dijo la doctora Celaya, en este caso puntual, vengo como integrante de la Comisión de Competencias que venimos pensando y concretando desde hace un poco más de un año en la Facultad de Derecho. La idea justamente es tratar de apoyar, tratar de darle todo el soporte posible a este tipo de competencias, de las cuales con las cuales ya venimos interactuando. Veo a muchos que ya han participado de algunas visa anterior, bueno, obviamente a la doctora Celaya, pero también a algunos otros. Quiero particularizar, no quedar con ninguno que me olvide. Desde ya a disposición la Secretaría de Relaciones Internacionales en este momento de atípica reforma en nuestra facultad. Nos van a encontrar ahí en la mansarda, arriba de la torre prácticamente, pero seguimos adelante con los programas y cualquier consulta que necesiten o quieran hacernos llegar, desde ya que estamos a disposición. También manejamos las redes, así que nuestro Instagram también nos pueden buscar. De mi parte, creo que la doctora Celaya ha sido por más explícita en lo que venimos trabajando mancomunadamente junto con la Secretaría Estudiantil, con la Secretaría General y con la Secretaría Académica en esta comisión de competencias que ya es un hecho. Muchas gracias.
Muchas gracias a ambos, muchas gracias a Augusto que está presente también, pero afectado a las actividades allí en la facultad. Well, let's start. Let's switch to English now to start this lecture. Today, our moderator is Maria Fernanda Frola. She is an English teacher graduated in Rosario at Olga Cossettini. She holds a postgraduate degree in English teaching from UNR. She has also a university specialization in education and technology. She is a think tank collaborator at Centro de Estudios Norteamericanos hasta Escuela de Letras of UNR, coordinating and investigating in American literature. She has been working for Programa Internacional in the field of legal English since 2018. She's an online tutor and in charge of developing digital material for cursos de idiomas con orientación jurídica para estudiantes de posgrados. Currently, she holds a cultural project to foster reading in English and lives in Bariloche. Thank you, Fernanda, for being here, for being part of this.
Thank you, Fer, and thank you, Programa Internacional, and everyone who is present here. Well, that was such an introduction, sorry. I wasn't hoping for that. Okay, well, hello, everyone. It's so nice to see some familiar faces here in this lecture. Let me know if you can see and hear me well. You can leave your comments on the chat. I'd love to see the chat active. This lecture is going to be very dynamic, so be aware and pay attention to all the activities that we are going to share with you. So, it is important for you to display your names on when you join us. So please go to settings and display your names. For those who don't know how to do it, you can click on participants, find your name, and then tap on it, and then rename. A box will appear, and in the pop-up box you will have you can enter your display name and then click on done, and you will rename yourself in case you don't have your first and last name. So welcome everyone to the Pro Arbitration English lecture event. We are going to start in 30 seconds when everyone is ready. So I invite you to leave your camera on and your microphones off. If it's possible, leave your cameras on, because we'd like to see who we are speaking to and your reactions, whatever. So let's start. As Fernanda says, I'm Fer Frola. You can call me Fer. I'm a professor here in postgraduate area. Yes. That's why I have the opportunity of living in Bariloche and talking to you right now. As you know, the aim of Programa Internacional is to join both fields of studies, languages and law, That's why throughout the year, we've been organizing different lectures in English, and we invited actually professors from our university and other universities to share their works in the field of law and in English. So this is a good chance for you to speak and practice language and, of course, learn something new in your fields of study. So thank you so much for being here and making the time to spend it with us. So you're probably wondering what's in store for today. So let me briefly tell you what we are going to cover to run down this event. It's going to take about 50 minutes. We're going to share some information on the importance of legal English, competitions, business law, arbitration, and the Bismuth. Okay, so I have two speakers with me today, and your participation is essential as we will have different pools throughout the event. Then we will move on to talk about legal English, business law, arbitration, and the Bismuth. And then we're going to do a Q&A section, question and answer section. So we will ask you to participate and leave your questions on the chat. So before we get started, I want to share some points so everything runs smoothly, okay? So from 1 to time, as I said before, you will see some pools on the screen. A link will be shared in the chat for each pool. So you can click on the link and you should be redirected to the voting page. Do not open your microphones, please, to answer the pools. You just simply use the link that we share on the chat and you will see the number of the pool and the link, okay? Remember that we expect you to be active, an active part of the event by participating in the pools and also leaving questions on the chat. So I'm going to be behind the scenes reading to your comments, reading to your questions, making sure that if you have any questions throughout the event, don't keep it to yourself, just write Q&A and the number of questions or leave your questions there and I will be in charge of collecting them for the last part of the event, okay? So just to check if the chat is working and everything for you, I will ask you to share your name and a bit of your academic background, or perhaps you can share from where you are listening to us. You can use the chat for that. In the meantime, we are going to start with our first pool. So the first question is, what legal English words do you know? Remember, we are going to share the question on the chat. I mean, the link for you to participate. Can you see it? So there
Yes.
you can write, okay, we are going to give you 1 minute for you to share what legal English words do you know. So you can write more than one word. You can start voting. Are you all in Rosario or are you in a different area of the country? Let's take 30 seconds more. Okay. All right, ready? I think it's time. We can share your answers. Let's see. Okay, so we have plenty of words, and some of them were voted many times or were written many times. Kidnapping, I like that. Okay, good. All right, fantastic. Thank you for participating. That was a good starting point. As you know, today we're going to, you will leave the presentation having reviewed and learned new terms connected to business law and what arbitration as well. All right, good. Well, as you can see, this activity is organized jointly between Programa Internacional and Comisión de Coordinación de Competencias, which is, as some of the members mentioned before, a new commission of the university that has been set up to promote the participation of students in a diversity of legal competitions held in Spanish and English, right? So legal competitions are mock judicial or arbitral proceedings where students examine and present their arguments in relation to a real case that has adapted for educational purposes. So some of them are national competitions like Competencia Interna de Derechos Humanos, and some other are international, such as Competencia Internacional de Arbitraje, the MUT Madrid, or the BISMUT, right? Now, let's keep warming up with the second pool. And now we're going to see a pool related to the meaning of a word. We saw it on the previous slide. That is, what is a MUT? So you will see on the chat, you will have different options. Yes, I think there are 4 options. You will have to click on one to vote. We will give you 1 minute for you to read the options and choose which one is the best for you, or is the correct for you. Let's see. Well, let's see the results. Okay. I can't see, Leonard, which is option. I think it's option A, the one that was voted the most, right?
I believe it's D, option D.
Ah, okay. Good. Thank you, Milagros. All right. So, well, you know that whether it's true that option D could be correct, it is true that English is a very flexible language, and this word can be a noun, it can be an adjective, and it can be a verb. The option that we're going to focus on today, that is option C, right? Which is a mock judicial or arbitrary proceeding set up to examine a hypothetical case as an academic exercise. It's like a trial or a discussion dealing with an imaginary legal case that actually is performed by students in exactly the same way as the real case, as part of their legal training. Also, it is true that option A, it's an adjective, yes, which means to be subject to a debate or a dispute or an uncertainty. And for example, when you say it's a moot point, no? When it's a moot point, whether, I don't know, building more roads reduces traffic congestion. So it's something that it is discussed or argued without not having a definite answer. That is when we use it as an adjective. And as a verb means to raise a question for discussion, right? Or suggest something, no? His name was mooted as a possible successor, for example, to suggest something for discussion. And option C is the one that we are going to, is the one that most applies here, right? Which is the legal meaning of the word, right? Okay, thank you guys for voting. Remember that don't forget to share your questions, yes, writing a Q and an A on the chat, followed by your questions. I will be behind scenes making sure that we go through all the questions until the end. Remember, don't keep to yourself the questions, just write it on the chat as soon as, if you're listening to the speakers and you have a question in mind. Okay, before giving an insight as to what's going to happen in this course, as to the end, it's going to be kind of a talk through or answer some questions that people may have before the end of this event. So I would like to summarize the importance of having a proficient level of English, right? You know, and in today's fast-moving and global market, an advanced level of English is really crucial for a practitioner. Having an advanced legal English allows you to communicate accurately, concisely, and clearly. So, as you know, practice makes perfect, so international moot competitions are a fantastic way for you to improve your level of English while you also acquire practical skills such as analyzing, preparing, drafting, defending a case in English through mock situations that allows you to put into practice your knowledge and to learn how to deal with experienced professionals. In addition, these kind of activities give you also a chance to learn about other legal cultures while you build an international professional network, which is really important. And it's also a main opportunity to open professional doors, let's say. Now, I would like to introduce you to María Elena Barbero and to Leonora Oguera Hakemet, who are going to be helping me out today with this amazing presentation they prepare on business law, arbitration, and the NISMUT. Hello, María Elena and Leonor. How are you today?
Hello, Fernanda. Thank you very much for this beautiful introduction. Thank you also, Fernanda, from Programa Internacional de la Facultad de Derecho, and to the Commission for para la Coordinación de Competencias Internacionales. We are very happy today to have a new activity. This new activity promoted these first pro-arbitration English lectures. As I was reading the words, the legal words that you put in the first chart, I saw that many of them depend on the context. Some were from criminal law, for example, some were from civil law, let's see. So today we will immerse in some specific words related to arbitration, related to private international law, and to this competition, which is absolutely great, where Leonora and me met. Let me tell you about my background very quickly. I am professor at the National University of Rosario of Private International Law. I was a former professor of criminal law and human rights course in the Programa Internacional. And I am also one of the coaches of the Bismuth competence. So thank you very much. And well, if Leonor wants to introduce herself now.
Thank you, Maria.
No, thank you. Also that everybody calls me Maria, so if you want to tell me Maria, it's
Sorry.
okay. Again, it's okay. Leonor, are you there? We can't hear you now.
Okay. So
Yes.
I was saying that it's great to see all of you and to be connected to this first event. Congratulations to all of you for organizing this first event and for also making possible that students can know more about the competitions and practice in their legal English, which is always something very important for the careers. And I'm really happy to be here and to share my experience in terms of arbitration, business law, and the Bismuth. I'm
Thank you,
a
Leonor.
dual qualified lawyer in UK and Spain, and I have been for the past 10 years an arbitrator in the Bismuth, and I have also been, well, somehow some kind of specialist on making new teams coming to the Bismuth and guiding them through all the different things that you have in this experience that is really enriching experience.
Okay, thank you, Leonor. I hear that you are in London, so thank you for being adjusting your timetable to ours. Thank you. Well, super guys, I'm really excited to listen to what you have prepared today for us today.
Maria Elena, I think that you need to share the presentation.
To share, sorry?
Share. Yes, I couldn't see the slides.
Yes, the Bismuth journey.
Wondering. Yes, so let's talk about the Bismuth journey. So we can talk for hours about the Bismuth, but we don't have time for that. So I will be really brief and I will tell you in just a couple of points what's the Bismuth journey. It's a competition for law students to foster the study and practice of international commercial sales, law, and arbitration. It started 30 years ago with only 11 teams, and this year we celebrated the 30th edition with 378 teams from over 89 jurisdictions. So more than 2,500 students and more than 1,000 professionals gathered for 1 week before Easter in Vienna. We had like 800 hearings in a week, usually, and the mood involves a dispute arising out of a contract of sale between two countries, which are parties of the United Nations Convention on Contracts for the International Sale of Goods, which we call it the CSG, and the students need to resolve international commercial disputes through arbitration as a team. And the competition is divided in 2 parts. The first part, it's like a written exercise where the students will learn how to work as a team, analyze, prepare, draft the legal documents. And then the second part, they will be encouraged to learn how to orally defend their case as a team also, and in English. And the second part is divided in what we call it pre-moods and general rounds. And there is where you practice really your advocacy skills and your arguments. The best team is the one who will win at the end. And the Bismuth is probably the best example of arbitration worth diversity and intensity. It's really making a rewarding experience for everybody that has been part of it. It's a life-changing event.
Well, Leonor, thank you. It is really, you already said it, it's a life-changing experience for all of us. In my experience, the students that participated in the moods, a lot of them are now living abroad, studied abroad, and I would say that all of them now work in very important in companies, and well, this whole network that they had in the Bismuth was totally important. When you have this on your CV, it is very appealing for the people because you know that not many people know this competition. And well, we really encourage you, if you are interested or if you know someone who is interested in this competition, to become part of the team of this next year, which will be in 2024. Leonardo, do you want to tell them what these
Marilena,
are about? Yes.
Excuse me, how was the first time you went to the Bismuth competition?
It was in 2018. In the
But
the
we
first
met
year.
in 2019.
How was the first time in your experience there?
Well, Leonor has much more experience, but I mean, my first experience, which was the first year in which the National University of Rosario participated, was in 2018. Then I went again in 2019, and then there are a lot of students here connected who continued with the Zoom because it was virtual because of the pandemic situation, and some of the others went this year in 2023, and the idea is to prepare another team for next year, 2024. But
that's nice.
Yes. Okay. Anyway, you will have a lot of time to question about this, to make questions, and also there is an invitation in the last slides to participate in this in the team of this year. Only to show you how big this competition is, we have chosen a couple of pictures. Maybe Leonor can tell you very quickly what they're about to show you there.
Yes. Well, I have selected two that I think are quite representative. So on the one hand, one is in 2019. So it was the year that Maria Elena and I met in Vienna. And the Bismuth was celebrating the 25th anniversary. So it was 5 years ago, and the directors wanted to do something special. So they organized and invited arbitrators for a dinner at the Rathaus, which is one of the biggest and more iconic buildings in Vienna. So if you look at the picture on the left, you can see the dinner with the lights, and imagine that there you have more than 1,000 people probably there. And then on the other hand, it's the picture about the teams. It's the picture about the opening ceremony. That's the big day for teams, and it's the kickoff of the competition in Vienna. And this year, in the 30th edition, 387 teams participated and gathered to start another edition. And they had the privilege to have the president of Kosovo, which is an ex-muti, so we call people that participate in the mutis. She was addressing the audience and explaining what was her experience as a muti and how that experience helped her to build her career. And well, the tricky thing about it is that the place has some kind of, well, it's limited. The concert house, it's big, but not as big as to make sure that all the teams can really get into it. So you need to be on time to have a seat. But in any case, you can always go to the reception, which is open for everybody. And it's also an amazing place to meet people, more than 3,000 people.
Yes, it's very difficult to explain the experience through pictures or some words. It's
you need to live it.
Incredible. Yes, you need to live it. Yes, life-changing experience. Well, now that you pay, let's see how much attention you pay to Leonor. We will try to make this lecture interactive, but at the same time, as we don't have much time because time is precious, we created this kind of polls. This is to see who of you has memory for numbers. Okay, Leonor said, how many teams participated in the 13th edition of the Bismuth? Maybe some of the students who participated remember that. If not, you can try. You can make, as
So
we
we
say
have
in
three
Spanish,
options.
you have 3 options. So if you don't remember, you can make the tate tea that we know in Argentina. There is also another way to do it. I hope that they remember, Lenore, anyway. When you're ready, you tell us. You can write in the chat, maybe, if you say it's okay, we did it, we finished. And so we can share the answers.
Don't be shy.
I gave you a tricky answer. If you don't remember, you just can try to guess. You have other opportunities. Okay? Can we share now? The answer is yeah.
So the first option
Yes.
seems to be the winner.
Yes, Leonor, can you explain the different options? Because you are tricky in this.
Well, basically, there were 387 teams in the 30th edition, but they came from 89 jurisdictions, and there were more than 2,500 students. So the right answer was 378 teams.
So there you can see how big this competition is. Imagine people from all over the world, really, from different legal cultures, different languages, different legal systems. That is what we wanted to show you with this question. Let me take here. One second. No, stop sharing. We'll move again to the presentation. Just one second. Okay, now can you see the presentation now here? It's correct? Okay, well, for everybody now, for those, maybe some of you are interested in the Bismuth, maybe some others just want to learn more about words legal English, and private international law. Let me show you the roadmap that we prepared with Lenore. We have first, we prepared 10 points. Don't worry, it will be very quickly. Some of them will be very quickly. I will develop first the first 5 points, which are more theoretical, focusing on private international law, which is the subject I teach at university, and then Lenore will tell you the other 5 points or issues related to a case based on a case which was in the Bismuth in 2018. It was obviously very simplified, but just for you to understand the theory. Let's start from business law. Probably you already studied commercial law, so you have an idea of what business law is. But to give you a definition, let me check, because I want to be precise with you. Business law, okay, don't rush, yeah? Business law is, we can define it as the body of rules that govern the dealings between persons or companies in commercial matters, yeah? The important part is that when we refer to rules, we are talking about something broader than legislation. It is not only legislation. We talk about, for example, usages. The usages that in international trade are widely known or regularly observed by contracts of the same type might also be business law. Business law has its origins in what we know as lex mercatoria, which was basically the customs of the merchants, and is the branch of law that needs celerity and effectiveness. In this slide, you can see many words related to business law: body of rules, business dealings, companies and traders, yeah? And you have to know that usually the parties agree upon what law is applicable to their contract and its effects. I mean, the basics of business law is a contract, yeah? And also here we can see some synonyms of what is business law. You can take it in the last options. It says trade law, commercial law, and mercantile law. That is to have a general idea of what business law is. Let's talk about harmonization. Yeah. Harmonization is the process that we need in international business law to create one background, or if possible, one legislation, let's say agreement for all the countries. When parties choose, I will talk about the little for harmonization, about the parties' autonomy, that for sure you know. When parties choose the application of the law of the state in their international contracts, they can select the law of the state, or they can create the rules that will apply. But usually problems in the application of the law or its interpretation may arise. So the best way to avoid this problem is through harmonization process, which can also be called as unification or uniformity of legislation. Yeah, let's see. Here, maybe you know what are the different family laws. We know that there we know different families of the law, Occidental families, Muslim systems, Chinese systems. But let's focus on civil law and common law systems. Lenore has more experience in common law systems, and I have more experience in civil law, though she knows the two of them because she is a lawyer in Spain and in England too. But let's focus on the main differences to make it simple. the legal backgrounds of the common law and civil law are totally different. Yeah. In civil law systems, the main source of law is the legislation, whereas in common law systems, it is the precedent, also called case law. The goal of harmonization is to create an instrument that reconciles in whole or in part the differences in the ways legal systems define and interpret cross-border commercial contracts. Harmonization may result in instruments that establish binding legal obligations or non-binding norms. In this way, transnational law can be used by international legal practitioners to bridge the gap between the different legal systems. So up to now, let's stop for a while because you listened to a lot of new concepts and new words. And let's play a little.
That was very concise and a rich explanation, Maria Elena. Now, how much of what Maria Elena explained are you able to recall? Can you write a synonym of business law? So remember, you can leave your questions also on the chat for the end. So write Q&A and the question that you may have, and we'll come back to it at the end.
Again, if you want to write in the chat, when you're ready, you tell us. When you're ready.
Remember that we would like to have as much as possible interaction, so you are a very important part of that interaction. Should we see the results? Here they are. Okay, here we have a lot of options.
Exactly, commercial law. Corporate law would be a part of business law. It's true. Also contract law. It's a part of business law. Yeah. Well, thank you. So
there is another synonym that has not been mentioned, I think, and it's trade law.
Exactly.
Yes, you're right.
Trade law.
The
exactly.
audience has a very good memory.
Okay, great. Great. Let's go on. Let's go on with this part, which is the more theoretical. Sometimes it's a little heavy, I say sometimes, but it's important to know it. We talk about the need for harmonization in international private law, and harmonization can be achieved by two main instruments, hard law and soft law. What is hard law? What are we referring to when we say the hard law? Probably you listen to that in a class, for example, because hard law are binding instruments. Generally refer to binding instruments involved and which can be legally enforced before a court or arbitrary tribunal. Here we have some synonyms to broadly speaking, because they have some differences, but in the way that, or some examples, let's say of hard law, which is convention, protocol, which is a convention which is complementary to another protocol, or an agreement here. So now, what is an international convention? Yes, an international convention or a treaty, it is an agreement between different countries that is legally binding on the contracting states. On this slide, you can see the website of UNCITRAL, which is a part of the United Nations, and it is a commission on international trade law. One of the best examples of harmonization through hard law is the Convention on the International Sale of Goods, which is known by its acronym. We call it the CISG. In the Bismuth, you will hear even a song related to the CISG.
Indeed.
Yes, indeed. This convention was signed in Vienna in 1980, and as for May of this year, 2023, it has been ratified by 95 countries, which is a lot. It is a very good success for hard law harmonization. But you can imagine that moving to this point, to the fourth point, soft law, and we can contrast hard law with soft law. We already know that soft law are non-binding instruments. That is the main characteristic of soft law. You can imagine that conventions take too much time to get into force, as the states have to first negotiate, then sign, ratify, enforce, and then incorporate their conventions to their national legislations. So sometimes in the path, let's say, to have this harmonization, this convention, we have the opportunity to create what are called soft law instruments. You could tell me, okay, but if soft law instruments are not binding, what are they for? Why do we mention them? Well, we can say at least three functions of soft law. First, we need to know that they become binding if the parties agree on their application in their contract. Secondly, some conventions make soft law binding in its provisions. For example, Article 9 of the CISG establishes that. And lastly, judges and arbitrators use them to interpret and to integrate the law when the intention of the parties in a contract is not clear or a hard law instrument. A convention needs further clarifications in relation to a specific case. You see here we have some examples of soft law. I will explain some of them. I don't know how much time we have. I will try to do it very quickly. But you can see here, for example, model laws. Model laws are templates for legislation that states can adopt totally or partially. For example, if we think about arbitration, we have the model law in UNCITRAL, which is the International Commercial Arbitration Law, which was partially adopted by our country, Argentina, in 2018. Then we have guides and guidelines. You can see there are a list of issues and topics for national legislators to consider when drafting future legislation that may impact in international commercial law. Model clauses, provisions, and rules are templates that private commerce companies can choose to incorporate in their contracts for cross-border transactions. Their use encourages the standardization of international commercial contracts. We may say that English is the language for business law, usually. in international law, we also have French, and the Hague conference some time ago this year adopted Spanish as the third language. But you can see that English is the most important one to create these contracts. Same, the codes of conduct that many companies have, they become binding when in the negotiation of a contract, they refer to their terms and codes of conduct. Terms, let's move on to the terms and international trade terms, which are words or again acronyms that carry specific meaning within a particular industry. And I will refer specifically to Incoterms. You see in this slide, in the right, that the Incoterms are the international commerce terms, which are compiled by the International Chamber of Commerce, which is based in Paris. And they are published usually and used a lot in business law. On the other hand, you can see the UNIDROIT principles prepared by the International Institute for the Unification of Private International Law. One of the most important sets of principles are those related to contract law. They are a set of rules based on the study of comparative law, and they cover the most important topics of general contract law, such as formation, interpretation, validity, which is not regulated in the CSD, and other topics. They are usually used to complement, again, the CSD. And finally, we have the International Bar Association, which is based in London, and which also create rules which are developed as guidelines and rules for arbitration, mediation, and legal practices. So here you have some of practical examples of soft law, which are used in private international law and specifically in business law. Let's make, again, a pool. I hope that you're listening to everything. Now, Leonard, share the link. Let's check. So now that you already know the difference between hard law and soft law, let's select one of the options and you let us know when you're ready and we can share again the answer. We are asking for a synonym of hard law.
So we have no binding resolutions, legal obligations that are binding on the parties, or legally binding instruments.
Yes. Also, if you
I think no non-binding resolutions. I believe it's that.
Just
okay.
Yeah.
Just answer in the link and we will check. Or even if you want to write in the chat a synonym of hard law, also you can do it. Maybe you remember one word or another to say, well, this is hard law, and you can share it to us.
Shall we see the results?
I think, yes, it's time.
Yes, the audience is listening. So we have 70%, which are saying that it's legally binding.
Exactly. And if we want to say a synonym of hard law, we can also say a treaty, a convention. Those are synonyms of hard law instruments.
Congratulations. Because
Again, congratulations. Let me check here with the technology. Okay.
so tell us on the chat in the meantime if you have learned any new words so we can come back to it at the end.
Exactly. Well, I will move on to my last point in this theoretical part to give you a background for private international law concepts, and it is arbitration. Related to the business law, we can say that in business law, usually parties, companies, have a provision in which they opt to select arbitration as the way to solve their disputes. Here you have one definition. This picture is for real. It was taken in one of the pre-moods. And here you can see that arbitration is a consensual dispute resolution process based on the parties' agreement to submit their disputes for resolution to an arbitral tribunal, usually composed of 1 or 3 independent arbitrators appointed by or on behalf of the parties. Let's make a difference between judicial system and arbitration. I selected 3 points only. There are many differences, but let's simplify it. First of all, the cornerstone of arbitration is the parties' autonomy. You see, it is a consensual dispute resolution process, whereas in the judicial system, it is the law. In arbitration, the parties appoint 1 to 3 arbitrators, that is the arbitral tribunal, 3 arbitrators, based on their expertise and knowledge. There you have, they submit their dispute for resolution arbitral tribunal, usually composed of 1 or 3 independent arbitrators appointed by or on behalf of the parties. They are a kind of private judges. Whereas in the judiciary, parties have no control over the determination of the judge. And finally, confidentiality, which is very, very important in the business area, let's say in business law and trade. In general, confidentiality is a key characteristic of arbitration, which means that the awards, that is the final decision of the arbitrators, are not published unless the parties agree. Instead, you know that in judiciary, the process and the judgments are public and available to everyone. So with this, we finish the theoretical, let's say, part of our presentation, and we will move from theory to practice. Again, if you have any questions, if you want to comment something, you can write it in our chat, so that in the end we can talk about. It is the public hard law. We will talk about that later. Diego, thank you for your
I have already noted down.
Thank you, Fernanda.
How are you? From 1 to 10, how are you feeling? Thank you, Maria.
No, thank you, Fernanda.
Are you tuned? Would you like to move on to the practice?
Is everything okay up to now?
We have a very shy audience today.
We have a shy audience. Yeah.
Yes, let's go. Let's see.
Okay.
Let's see.
Well,
good.
Leonard is going to move on to the practice. part of the talk.
So thank you, Fernanda, and thank you, Maria, because you have explained very, very concisely, very basic concepts that are really important to understand arbitration business law and how we use also the legal terminology in arbitration and business. Basically, if we put all of this in a case, we will probably see it a little bit more, well, a little bit clear, because sometimes when we are talking about hard law, soft law, arbitration, or even harmonization, it looks like some kind of vague concepts. So let's imagine that we have a case, and this case is based on the 2018 Bismuth case. And you are a counsel, so you are the lawyer, and you have a client who comes to you because suddenly they have an issue. There is a dispute that has arisen out of the contract and they need some help. So let's look a little bit about this case. What are the facts? So we have the parties. The parties are your client, the claimant, which is piece of cake, and who is based in country A, which is a common law country. And then you have the respondent, who is a gourmet supermarket chain, which is called Honest Food, and is based in country B, which is a civil law country. And there is some kind of contract between them. They sell cakes, and respondent buys the cake, chocolate cakes. But to have the ingredients, they need to have a supplier. So your client has another contract with the supplier, who is Pure Chocolate, who is based in country C, which is also a civil law country. And the basic point here is that the chocolate has some kind of certification, because it's quite important that we know that the ethical and environmental sustainable chocolates for the trade business, it's appealing. Nowadays, people want to be more environmental friendly consumers. So that's why they are buying these cakes from your client. Everything seems to be fine. So let's see a little bit how the agreement started. So you have, on the one hand, the respondent, which is, as we said, the supermarket, who will issue a tender saying that they want 20,000 cakes daily from Monday to Friday from the 1st of May 2014. And your client make a proposal, but they decide to make some kind of alterations, amendments, and they propose it to the respondent, who will be the buyer. They are the sellers, the others are the buyers. And the buyer, so the respondent, seems to be happy, and there is an acceptance. So we have an agreement, we have a contract. And everything seems to be fine, because they start to deliver their cakes. So 20,000 cakes per day, everything seems to be fine. However, suddenly the problems start. Because suddenly 2 years later, there is some kind of problem with the chocolate that is used to make the cakes. And it seems that there is some kind of fake certificates. So there is an issue with the certification scheme, and there is an investigation. So the respondent, the buyer, asks your client, the claimant, what's happening? And your client says that they will ask their supplier if they are involved or not, because it seems that in the country of the supplier, the problem is quite a big problem. So before moving on, we are going to have another tool. And I think, Maria Elena, you need to go one slide. Yes, there.
Yes.
And I would just ask you, how many contracts do we have in this case so far? And I will share in a moment the link so you can give us the answer. Remember, we want to know how many contracts do we have. And here it is. So we have the pool 6. It's here, and just give me a second. And you have the link. So, do you think that we have 3, 2, 1, or there is no contract?
Gonzalo is ready.
You can write on the chat if you are ready. Okay, we have different options here coming. Let's see the results. So, it seems that we have right now 58% of the audience that think that we have 2 contracts, 33% that think that we have 3 contracts. Okay, now it's 62 that think that we have 2 contracts, and 31% that think that we have 3, and only 8% think that we have 1. And nobody thinks that we don't have a contract. So, Maria Elena, do you want to share your thoughts?
Yes.
So here, basically, the problem is that we have a main contract, which is the contract between the claimant and the respondent. And then we have another contract between the claimant and the supplier. So we have 2 contracts.
You see
There
here?
is no contract between the supplier and the respondent. Okay, let's now move to the problem that we were having, like investigation, and what exactly is happening. So we have your client that has been asking the supplier if they have an issue, and because there is a big scandal and they are involved in this scandal and they want to know exactly what's going on. So they send a letter, they are asking exactly what's happening, and then they have a response. And the respondent said that they were not going to pay until this is completely clear. And the claimant is stopping to trade with the supplier because it seems that the supplier has been involved in this scandal. And they sent a communication to the respondent telling them that even if the supplier seems to be involved, all the cakes that were delivered were really containing chocolate that was really environmentally sustainable. So there was not an issue. As you can imagine, the respondent is not really like happy with the situation. So even this communication doesn't sound very good for them. So the problem is that the respondent is not paying and the claimant wants to still have business with the respondent, but the respondent wants to sell cakes that are not misleading the clients, the final client that wants a cake with a sustainable chocolate. So what happened is that at some point, we need to understand which is the main contract. So we are going to share again a link, and you can give us your thoughts. If you have been listening, you will probably find it very easy. And if you have a doubt, we can also go through it at the end and clarify any kind of question regarding this kind of questions that we are asking you. So you have the link.
Is it working okay?
Yes, it is.
Okay, good.
So tell us when you are ready so we can see the results. Should we see the results? Are you ready for it? Okay, here they are. Okay, so we have only 4 questions. 4 people have answered the question. It was a really difficult question. No, come on. It was quite easy. We have one contract that is the main contract, which is between the claimant and the respondent, which is also the seller and the buyer of the chocolate cakes.
Here it is. Sorry, Lenore, but here we have something interesting, Fernanda, related to some words, yeah? Because we have seller and buyer, which is in the context of the contract, this international sale of goods contract. And in the context of arbitration, we have claimant and respondent. And plaintiff refers more to a judiciary process, to a judicial process. So you see how important it is to know the specific words, because when we talk about a contract, we refer to seller and buyer. Not now to claimant and respondent, even if we understand that the origins of arbitration is also a contractual origin, but we are not talking about the contract of arbitration. We are talking about the main contract, and the main contract is the sale of goods here. So the parties are the seller and the buyer of the chocolate cakes. Thank you for all the answers, because this is what we want, to share different words and to understand exactly this. Leonardo, do you want to add something?
Of the difference in the shade of meaning, right? When we were discussing also about the different shades of meaning of mood, for example, right?
For example, the context. Exactly. Thank you. Oh, let me present. Do you want to go on?
Yes, I was going to say we come to the case. So we have one of the contracts that is with the supplier that has been having some issues. So your client has stopped to trade with the supplier, and they are still trying to trade with the respondent, the buyer, but the buyer is not happy, it's not paying, and the claimant will say, okay, as a gesture of goodwill, I will offer you a reduction of 25% of the price of the 6,000 cakes that have been already delivered and yet paid, okay, for. So they tried to find some kind of solution, and the first option, when they look at the contract, they have a clause that says that, okay, let's try to do some kind of mediation. So the difference between mediation and arbitration is that the mediator will not make any decision, will just try to help the parties to find a solution, and when they are not really finding the way to express their issues, the mediator is helping them to find the best option to really understand the different positions that they are having. Okay, but this mediation is not properly working, and at some point, one of the parties says, okay, let's look at the contract and see what we can do. And then it's when they are trying to find how they can resolve this issue. And there is in the agreement, which is like, remember what Maria Elena mentioned about the autonomy of the parties. So that's the important thing. So they make different decisions about what they wanted to have as rules between them. But one of the parties is from a common law country and the other one is from a civil law country, when sometimes they might see things from a different perspective. And that's when all this point about harmonization, it's important, because in their contract, they have included different points that will help them to make that kind of decision about how to resolve this issue. And one of them is that this kind of party autonomy will allow them to decide about the governing law of the agreement, and the other one is the clause, about the arbitration clause. So what is the other word for contract? This one is really easy. So I hope that everybody will participate on this one. And we'll have like a lot of answers. And because it's, I think I have repeated like 20 times, probably. So let's see. This is really the kind of thing that probably you are not having any doubt about it, but we are going to see the results. And here they are. Let's see how the interaction is going from the audience. Okay. So we have 9 people that have been 10. That's nice. Oh, wow, we have a lot of words here. 11. Is someone else trying to answer the question? Okay, so the word is agreement. As you can see, many people have been writing the word, and I think that we have like different words here that are maybe something that Fernanda or Maria want to make some comments about.
I think that when we refer to, for example, an arrangement, it's not a contract itself, but it's something that you organize with another person. Like you can arrange a doctor's appointment, right? And deal is, I think it's much more informal. It doesn't involve into this question of writing something and committing to something else, to doing something, let's say. Treaty, I think it has to do much more with international organizations, and I guess that it's a big contract. No, I don't know.
It's like
I'm
a
just,
contract. It's like a contract between
yeah.
states. But
Yes,
again,
exactly.
the context of the word contract won't be correct in this case. But it's interesting
Exactly.
the relationship that we do. I am a little curious about the word bargain. Bargaining. What do you think,
Yeah,
Leonora,
me
about a
too.
contract? In India, of course, bargaining is the rule to celebrate contracts, but
it's not a
Yeah.
synonym of contract.
exactly. It's a way in which actually we negotiate in a competitive negotiation. We bargain the price. In some cultures, that is the rule. In Mexico, in India, in Thailand, you have to bargain, otherwise you are not going to make a deal. Yes, informally to make a contract. Yes, and the other is, yes, settlement. What can you say about that, Fernanda?
Well, it's basically in arbitration, that's a very important word, because
Yes.
usually the parties can settle a case even when you go in front of the judge before going to the trial. You can settle the case.
Right.
Between
Like
the
a solution,
parties.
you mean?
Yeah,
Like,
it's a solution, but it's not a synonym of contract, I'm afraid.
no. It would be
But
like the
it's really
result, right?
interesting to see all these options here. Because we can go through different words that are pretty important legal words that practitioners use. And we can clarify the difference between them. So I think that all your contributions are really valuable. So thank you for interacting.
Yes, thank you very much. Now I will share again.
Let's come back to our case. So before Maria Elena shared the slide, let's do a summary of the things that we have, like the claimant, respondent, the supplier, two contracts, the main contract, the subsidiary contract between supplier and claimant, which is your client for the moment. Let's come back later about this. And we have the case, we have a certification scheme, we have a scandal, we have an attempt to resolve the issue by different emails, communications. We have one point that the contract with the supplier doesn't survive and there is a big issue there, but we are trying to resolve the problem with the respondent, and we have tried the mediation. But the mediation, unfortunately, has not been really getting to the point of resolving the issue. So we look again at the contract and we find that there is an arbitration clause, which is also one of the things that the autonomy of the parties can make possible, because they make the decision to include the arbitration clause. So you can see here on the screen an example of how an arbitration clause is usually drafted. And it's a provision, basically, that says that any dispute, controversy, or claim arising out of or in relation of the contract, or even the breach, termination, or invalidity thereof, shall be settled. We were talking about settlement, the verb settle, by arbitration in accordance with, and you specify there the parties can decide which rules they apply. So you remember that Maria was talking about the ABA rules? So you have many rules, many arbitration centers have their own rules, and the parties, so the businesses, can decide which ones they want to apply between them in the event that they need to resolve an issue arising out of the contract, or, as we said, related to, or when there's a breach, termination, or invalidity. And this is without the involvement of any habitual institution. It can also be. So sometimes the parties may do everything as they want, or sometimes they ask an habitual institution to help them to resolve the problem. So in this arbitration clause, they decide the number of arbitrators. You remember that Maria Elena was talking about the difference between arbitration and judicial system? So in this case, the parties agree that they will have 3 arbitrators, and they will decide what kind of knowledge or expertise they want, and each of them will appoint 1 party. They will not nominate, they will appoint the arbitrators. And the 2 arbitrators that will be appointed by the parties will appoint, let's say, or decide which will be the presiding arbitrator, and that will be the arbitral tribunal. And the difference, as we explained before, is that the arbitrators will make a decision. So they will listen to the parties, they will listen to the arguments, but they will make their decision about the issue, how they can resolve the situation, or who is right or wrong. And it's binding on the parties. So the parties, in the autonomy of the parties, they agree that they will be binding. And the other point that we were talking is the governing law and the CSG. So the autonomy of the parties, they can decide which law applies to the contract. And that will be to the substantive part of the contract. And here, the convention that Maria mentioned, it's one of the conventions that is usually in the main convention applying to the case in the Bismuth. So here you can see an example of the governing law, or choice of law. So it's quite clear, okay, that the sales agreement shall be governed by the law of a place, a country, in this case is country A, okay, including the United Nations Convention on Contracts for the International Sale of Goods. In this case, they have only mentioned the CSG. But what happens if this hard law, it's not enough to resolve the situation? That is when the soft law comes. And if the parties agree, it will be used where the hard law it's not helping them. So for example, in the Bismuth, we usually have the unilateral principles that will be used to help on that point. Are you following me? Okay, now we will see what the CSG, a little bit the structure. So as you can see, basically, we have like one part that is the sphere of the application and the general provisions. And then we have a second part, which is the formation of the contract. So the formation of the contract. And we are not talking about the validity of the contract, just the formation of the contract. And the third part is the sale of goods. It's where you see the general provisions, the obligation of the seller, the obligations of the buyer, and all these kind of provisions that are more or less common to both of them. And then there is a second part on the CSG that is a little bit some kind of explanation note by the UNICITRAL secretary that helps a little bit to clarify certain points. And they relate to the scope of application and the general provisions or the formation of the contract. Again, the sale of goods, and also some clauses that might be a little bit not so frequent. So we have all of this. And the question comes. So have you been listening to us? Which of these issues is not regulated by the convention, the CSG? This one might be a little bit more tricky, but I'm sure, because you have been doing it wonderfully, that you'll do it perfectly now. And
I also mentioned
amazing answers.
I also mentioned it, so just to help you. So you heard it at least twice.
Okay, here's the link. Tell us when you are ready. So let's see the options. So we have option A, which is obligations of the seller. Option B, which is obligations of the buyer. Option C, formation of the contract. And option D, validity of the contract. And I want to make sure that you understand that we are looking for the one that is not regulated by the CFG. So, okay, someone is saying that it's done. Great, wonderful. Tell us, and when you are done, we share the results. A little bit more time. Okay, someone else. Fine, great. Great, great. So, let's see. I'm curious to see the results. Okay, shall we close? Okay, let's see the results. And you can still vote in the meantime. Here it goes. Okay, so we have here option. Okay, we have 10 people, 12 people, wonderful. So option D, we have 50%, which is the validity. We have option C with a 42%, which is the formation of the contract. 8% for the obligation. Okay, and we don't have anybody thinking that this is the option A. So, Maria Elena, do you want to say something?
Well, option D, I don't really see. Option D is the validity, so 50% answered correctly.
That's
right?
it.
That's
Mhm.
it. Okay. So,
So
the CISG, yes, I want the CISG. Of course, would be another lecture. Yes, to know about this is very quickly to show you some of the main topics that the CISG covers. But imagine that it was very difficult to make, let's say, a hard law instrument between a common law and a civil law systems. And one of the problems was to incorporate the validity of the contract. Also, another one was the transfer of property of the woods. That's another issue which is not governed by the CISG.
And when we have some kind of issue on this regard, we tend to look at the UNIDROIT principles, which most of the time will clarify. So the
right, if
hard
not,
law is the CSG and the UNIDROIT principles, the soft law.
Or to the private international law of the unspecific state, but that is a little more complicated.
But
Regarding
if you want
conflicts
to
of
know
law.
more about this, the best experience is the Vismut, because in the case you always have the CSG that is involved. So you will know everything about the CSG if you participate in the competition. So let's go to advocacy and hearings. So coming back to our case, so we have the parties that they don't find a solution. So one of the parties says, okay, we cannot find a solution. There is no settlement that can be reached. So we need to just send a notice of arbitration and start with the arbitration. And then it's when you have the hearing, once you will prepare your case. The 3 arbitrators will be there, and you will be the claimant, and you will defend the arguments of your client, and the other counsels will defend the arguments of the respondent. In the Vismut, you will defend both. In some hearings, you will be claimant, and in some hearings, you will be respondent. And Maria Elena, maybe you want to comment about the picture? Because
Yes,
I think it's a real picture.
This is a real picture. It was taken in 2019 with our team. Our team is on the right, the two boys, and well, you can see that the experience of the bismuth and the pre-moods are really very similar to real life. So, and the cases are very complicated. So here we are a little, well, we pass the time a lot, but there you have to speak 15 minutes. And it is in Vienna. So imagine that 15 minutes are 15 minutes, not 15 and a half or 14 or 10 or etc., for example. And well, the arbitral tribunal, you can see there 3 people from different countries, different cultures. Sometimes even when Leonora and me, we can tell you about different experiences, but well, I won't say it after before the pool. I will tell you my experience after the pool, because it is related to the last pool for you. So now pay attention to it, because it's the last one for today. Probably you are tired because it was a lot of information, but we can assure you that it is the last effort you have to do. Let's address to the final pool, and then maybe Leonora and me can share you some of our experience. How would you address to an arbitral tribunal? How would you address? Is that clear, the question? Do you understand what the question is about? Or
so
do you
imagine that you need to say something to the tribunal. How would you start the
You
sentence?
have to be polite.
Yes.
Exactly, but the important part of here is how you refer to, how do you address, what do you say to them? You have 4 different options: Your Excellency, Your Honor, Mother, Mrs. Arbitrator, or Mr. Arbitrator, or Mr. Surname. Let's say, for example, Mrs. Barbero, or Mrs. Our Document, or Mr. Jones, for example. Remember that I will give you a clue. Remember that arbitration is a more flexible proceeding than the judicial system. Maybe that helps me. I'm not saying that it is not formal. It is formal, very formal, but we have more flexibility.
Wonderful. Some people are reacting. Thank you. Thank you for telling us that you are ready. So,
okay.
Shall we share the results? Yeah.
Please.
And here we are. So, because I think that the slides you don't see them properly, so I will just make sure that you understand the results. So Your Excellency, oh, we have a variety of answers here, I think. Let me just see why this, I don't know why I cannot see. I cannot see the percentages.
Sometimes technology is tricky.
Yes, it's indeed.
But as it is the last poll, if you want, you can answer that with your, you can put on your microphones and tell us what you think. How would you address to an arbitral tribunal or to an arbitrator?
I would say
Gonzalo?
Mr. or Miss Arbitrator, yes.
Okay.
I think that would be correct.
Okay. Other
To
options?
say Your Excellency is, for example, to a judge, it's extremely formal to use that word.
And Your Honor? What about Your Honor?
I think I will use that the same in front of a judge.
But it's clear. Yes, it's not a judge. It's an arbitrator.
An arbitrator, yes. So I think Mr. or Miss is enough.
Marina, what option did you select? What option do you think is the correct?
The same option as Gonzalo.
And why not? Why not Mrs. Mrs.
Maybe two.
Sacramento, for example?
Maybe both. Mr. and Mrs. I'm thinking yes, it could be, but yes, because arbitration, if arbitration, it's formal but not formal like a trial, a judge, we can use Mr. and Mrs.
Yes. Any other opinion that you want to share with us?
Okay. So maybe you want to share your experience. I share mine, so that would give the answer.
Yes, I will tell you my experience in 2019 when it was my first experience as an arbitrator in the Bismuth. I was arbitrating with a lawyer from the House of Lords from London and a PhD from the University of Vienna. And we had two teams, one from Kuwait, two girls, and another one from Germany. And I remember that the girls from Kuwait, who were dressed typically and traditionally as they dress, and in Muslim countries, they all the time said, "Your Excellencies, I want to tell Your Excellencies." And when it came the moment to give the feedback, because when we act as arbitrators, we have to make a feedback. The Lord of the lawyer from London told me, "Okay, Maria, do you want to give the feedback?" And I said, "Oh my God, I am from Argentina, I have to say." And I said, "Yes, it was good." And I said, and I clarified, "Sorry, this is not my mother tongue, but I didn't feel comfortable when the team from Kuwait referred to me or addressed me like Your Excellencies. I didn't feel very comfortable." And then the two other arbitrators said, "Yes, you're right. That is too formal for here. We don't say Your Excellencies, but probably in their country, they refer to the judges or maybe to arbitrators. We don't know. We don't know, maybe, because we can have different languages in that case, as Your Excellencies." So that is my experience to show you the background, the intercultural background, and how language, we try to unify the language in English, but anyway, as it happens in law, we try to make unification, harmonization, but every time we put something from our culture. That is the difficult part of harmonization, of using one language, yeah? So that's why it is so interesting to make these kind of exercises. Leonardo, you want to tell them your experience?
Yes, I was trying to share mine. It's like, as I always have, in the Bismuth, the tribunal is a very diverse group of people from different backgrounds, different nationalities, even different languages sometimes. So sometimes they will speak the same language, but they understand the language in a completely different way. And the teams were using Your Honor. And one of the arbitrators said, "Well, you don't know me to say if I'm honorable or not."
Right.
So be careful with how you understand oral rule, because sometimes it can be seen as something that you are judging them personally, and that will not make, will not help you to interact with the tribunal in a way that will be like in your favor if they take it in the wrong way. So this goes to another experience that I want to share, that it's not related to our question, but with the wordings. And it's in another competition that I participated as an arbitrator recently. One of the team from Singapore was referring to the other counsel, so the opposing counsel, as my dearly friends. And that was also some kind of thing that we were making some kind of comments. Because in the UK, it's true that in a trial, you can call sometimes barristers, sometimes they do that. Yeah, my friend, my dearly friend, in a way that is like very polite. But in an arbitration context, when you have people from different backgrounds, it can be very confusing that you're calling your friend someone that is supposed to be like the opposing party. So what I want to say as a conclusion is that one of the important thing about the legal terminology is to know how it means and when you can apply that kind of word, because sometimes the word is really specific to a context. And if you apply the word in the wrong context, you can get a completely different result. And again, if you want to improve your legal English, the Vismut is a really, really good experience, because you need to defend your case in English. So you need to really increase your vocabulary to be able to explain the case and use it in a very, very concise way, but also in an accurate way. And Maria will talk about it.
So to sum up, the answer, the correct answer, were the two, we could say the two that you mentioned, Mr. Arbitrator, Madam Arbitrator, or Mr. and the surname, maybe probably more correct even, but both are correct. And the other is not related to your honor or your excellencies. Well, to finish our presentation of today, this is an invitation. Here we have a lot of students and professionals that participated in the Vismut in previous years. And well, we're looking now for new students to involve in this live teaching experience. This is, here you have our Instagram. You have the date of the next meeting. And well, usually the requirements, we say, we are not talking about that you have to have this level because you have a certificate that says that you have a B2 or C2. The important thing is that you manage, that you have a good level of English. Taking into account what Leonard said, legal English is important. Legal competitions in English help you a lot to understand English. Also, my suggestion is start legal English also in the Programa Internacional, because legal English is very helpful, and now we need English for everything, really, for everything. Just for you to have, I don't know if you want to explain that, Leonor, but to know the schedule of this life-changing experience, but hard-working experience, very demanding. The case will be published on October, and the hearings in Vienna will be in March, exactly before Easter. And in the meanwhile, well, you have the team registration. That's why we need money, because in Argentina, the dollar and the euro are very expensive nowadays, but we will manage to go. We have clarifications, memorandum for claimant and memorandum for respondents are the written part of the competition. And then, as Leonor said, we have the oral rounds, first in Primuts, which are celebrated all around the world, really all around the world. in New York, in Miami,
In Paris?
in Hong Kong, in Paris, where we met, everywhere, in Rio de Janeiro, in Buenos Aires was last year. So there are primutes almost everywhere. And then the hearings in Vienna, which are, well, what can I tell you? One of the best experiences that I had in my whole life in international law, in private international law.
It's a very intensive journey.
Yeah.
Of 5 months, but it's really a life-changing experience. So when you start, you don't even guess how much you will get from this experience. And the more you give to the Vismut, the more the Vismut gives you.
We wanted to share with you some of the pictures from the other years. This is the wonderful team that represented us in this year, 2023. Some of them are now connected. I saw you. These are some pictures from 2018 and 2019. Here we have a primut. In the one that I am the only woman, it was a primut in Budapest. It was really a great experience. So it's another way for women to become part of this competition, to become part of.
And
Yes?
one of the things is that the Vismut is really equal in terms of gender, so they really give equal opportunities to women and men.
Exactly. That's true. Well, there you have our email and Instagram, and we want to thank you very much. Especially, I want to thank Leonor for this presentation, because it is now, I guess, 5 hours more.
Yes.
Okay, so it's very late. It's very late, and thank you very much. I will stop sharing the presentation.
Thank you, Maria and
Thank you,
Leonor.
Bernard.
It's really interesting how well, all the experience. I'm always very curious about these cultural experiences, because even though you learn how to be on the spot, no, I guess that the most important aspect is this, how you connect with people from other countries and learn from one another, apart from the experience itself connected to legal issues and arbitration. I mean, there are, from whatever point you see, the experience is really enriching, and well, the ones who were able to participate are really lucky to have to be able to have done that. So I think it's really amazing. And well, something there was a question on the chat from Diego. He mentioned if is the order public or public order hard law. I don't know, Maria, if you want to quickly answer to these questions, or perhaps Diego, you can expand on that.
Excuse me.
Yeah, go ahead.
My English is very bad, but in my experience, the hard law, the orden public, the arbitration applicable law, the orden public law is limited. The autonomy de la autonomía de las partes. Excuse me.
The
The
autonomy of the
parties.
parties.
Okay. This is it is how law the orden public.
You're muted, Maria.
Maria? You're mute.
I don't know why I was mute. Sorry. Thank you, Fernanda, for telling me. Diego, what I wanted to clarify before answering is that when you're talking about public order, we are in the context of private international law, like to say the limits for parties' autonomy and the limits to apply foreign law. That is the way you are talking to us as public order, or is it another concept? Because probably I will understand public order from private international law, and maybe my answer won't be the one you are expecting. You did the question. It wasn't me.
My English is very bad.
If you want, you can say it in Spanish, so we can
Yes.
answer in English, but at least Maria knows what you are referring to.
Yes.
Ok. En mi experiencia, perdón, Spanish,
No problem.
mi experiencia en los arbitrajes, el límite que, más allá de la legislación elegida por las partes, el límite, por ejemplo, que aplica el tribunal, el panel, está determinado por el orden público, lo que es el orden público, de acuerdo al país donde se está realizando el arbitraje. A eso me refería.
Okay, perfecto. Okay, so I will try first to answer in English, and if it's not clear enough, I would say that in Spanish, because it is I won't say public order is a hard law. It is not hard law or soft law. Remember that when we talk about hard law and soft law, we are referring to instruments in harmonization of law, so different legal systems. What you are saying is that public order is from one country and refers to the principles behind a legislation from one country. For example, let's say that there is a contract in an international contract to international trade of people to be slaves, let's say. That is against my public order. The public order, so I won't recognize that contract. I won't apply a contract in which there is something related, or for example, a contract related to, I don't know, Egypt, for example, in which there is not equality between women and men, for example. There is a discrimination. But when we say public order, we refer to the principles that are behind the legislation of one state, not harmonization. So I won't say it is hard law or soft law. That is not a classification that I would use for that. Yeah, so it is hard, very hard answer, but it's not related to hard law and soft law. Those are the principles in which we say, okay, I can apply a foreign law, or I can respect your contract, but these are my limits as state. That is a public order. Those are the principles, and it's not a norm. Let's say it's not a legislation. It's something more important even, and it changes from one to the other. For example, divorce. Divorce used not to be legal in Argentina, for example, and then it changed. And what happened with the couples that had a second marriage and they didn't obtain in Argentina their divorces? Was that second marriage valid or not? And as there was a change in our legislation, those second marriages were valid. Why? Because as legislation changed, our public order changed, because our principle is now that people can divorce, for example. I don't know whether I was clear or not. I tried to, because that is very specific from private international law, But remember, when we say hard law or soft law, we're always referring to harmonization. Public law is totally the opposite. Let's say we will never make a harmonization of public law public order. Even if we think about human rights, because some people refer to public order as human rights, for example, which is not exactly the same. And we know that in the Occidental countries, human rights are not the same as in the other parts of the world, for example. Could I answer? Yes. Do you want to add something, Leonor?
Yeah, I just want to make a point that is that when you have an award, which is the equivalent, let's say, to the judgment when you are in the judiciary, okay, the arbitrators will issue an award when they make their decision. Sometimes this award can be challenged on the grounds of public policy, and that would complicate the enforcement of that award in a country. So that's why also you need to take that kind of public order into account as an arbitrator to avoid these kind of situations.
Exactly, that's true. Also in that order.
Thank you, Diego.
Thank you, Diego, for your question.
What's your opinion about sport law? Sport arbitration. That's a tricky question.
But it's your opinion. You can make an opinion.
The thing is that it depends about what kind of issue is at play. Because if we look at, for example, a contract in the football context, but that is related to the intellectual property rights, it's very commercial.
Sorry, the question, I couldn't read it, but it was about sports law?
Yeah, it says that, what's your opinion about sport arbitration? Is it a part of commercial arbitration, or does it have its own autonomy? Recently, the European Court of Human Rights found Switzerland responsible of violation to due process, among other human rights violations. It stated that the Swiss Federal Tribunal should have granted a wider revision of an award rendered by the TAS or CAS, depending on which language you look at it,
exactly.
related to sports matters, due to the fact that when parties submit their dispute to arbitration, they are not in as equal conditions as they could be in cases of business law arbitration. The case was Castor, Semenya, and against Switzerland. And here's what I'm saying, that it depends about what we are talking about. Because in this particular case, it was one person. It's not.
Yes. I don't know, Guido, if you want to add something to your question, which is really,
in the case,
really interesting. Yes.
The International Federation forbidden this athlete to participate in one competence because of her high level of testosterone. And she stated that it is a violation of their human rights because of sex discrimination.
And so, what do you think?
It's a tricky question because they are discriminating her, but also they are trying to protect the competence, because if they let her compete, she has a great advantage over the other female athletes.
But let's divide the topic. Let's say, if you ask me if what I think about sport arbitration, I think sports arbitration is totally a very good way to. Am I connected? Yes. I think it's the best way to solve sport disputes. The arbitral tribunal, the TASCAS, because of its speciality, its knowledge in sports. Another question is that related to the human rights and what you are saying about equality and etc. Well, I think that it has to do more with the arbitrators in that case, and the new challenges that we have in this world, which is changing all the time. Yeah, and we have to adapt to new realities. And sometimes this links me to the question of enforceability of the award. Interesting. Would that be enforceable or against the public order? As Diego said, yeah, that's interesting.
Yes, excuse me, teacher. En español, en español nuevamente.
Español.
Sí, en esos casos, o sea, yo litigo en el TAS y en el CAS.
Sí.
Y el límite está en el orden público del derecho suizo, de la pila.
And why? But why? Do you know why?
Y en el caso Semmedia, el límite está en el derecho público suizo y ahí eso es lo que habilita la apelación ante el Tribunal Federal Suizo.
Exactly, because Switzerland is the seat of the arbitration. Yes, the seat, that is the concept. The seat of arbitration is in Switzerland. In Lucerne, I think, the TAS, yeah?
What?
Do you know what is seat of arbitration? The place of arbitration?
The place es in Zurich, but la realidad es que las audiencias se hacen en distintos lugares del mundo, pero la realidad es que la ley aplicable es la suiza.
In Lausanne.
Well, exactly. In Lausanne, exactly. But the question is, do you want to explain very briefly, Leonard, the difference, what the seat of arbitration is? Because it's not a geographical question.
You know, I was thinking that that's probably your next event about pro-arbitration. So
Yeah,
to explain the seat, the venue, and the importance of the language. That will be probably something that they can really learn, because we can talk about many things there.
Yes, but Diego, just for you to know, the seat of arbitration or the place of arbitration has nothing to do with where the hearings are held. It is a legal concept which refers that if there is any problem arising from the arbitration, and you have to go to a judge, let's say informally, the competence and the legislation would be from the judges of the seat of the arbitration. That's why the courts of Switzerland have let's say the competence, and that's why the law of Switzerland is applicable in those cases. That's it. It's so interesting.
Basically, the seat is the location that is selected by the parties. We come back again to the concept of party autonomy.
Yes,
so
but
they make the
location, the legal location, not the geographical location.
Yeah, is the legal place of arbitration. Then the venue is where the hearings can take place.
Yes, and the TASCAS is another very interesting lecture that we can have from different arbitrators that are in the TASCAS. I remember when I studied in Buenos Aires, I had a professor that is one arbitrator from TAS, and he explained to us many things, because it is really very it is tending to be the trend is that it would be autonomous, let's say. The sports law, it's has its own rules, especially international sports law.
By the way, there is also a legal competition, arbitration competition about sport arbitration. That is organized.
You can start with that. Okay, yes.
And by the way, if someone wonders, FIFA doesn't have many places. They only have one place, the FIFA house, because I have been there. That's why I'm saying that. And many people tell them, oh, you are in Switzerland, and then you are also when they have the World Cup in another country, so they have different places and people work from different places. The answer is no. All the lawyers working for FIFA work in Zurich, in an amazing building, surrounded by an amazing garden, but they are not traveling around the world. Most of the time, they're just there.
Well, guys.
And they have arbitration.
Thank you.
That's nice. Well, if there is any other question, we will wrap up. Thank you for enlightening us, Maria and Leonor. It's been a pleasure to listen to your experience and, well, to this amazing field of law that is arbitration. For me, it was, I heard of this, but for me, it was new and very interesting. Thank you for everyone who has stayed and shared their insights. I don't know, Fer, if you would like to say something else.
No. Thank you very much. Thank you, Marie. Thank you, Leonor. Thank you, Fer.
You're
See you
welcome.
next time.
Yes, thank you very much. And Fernanda, this is another topic that we can talk about, the European system and the control of the violation of human rights from the European courts. It's another interesting topic because in Latin America, we don't know very much about the European system.
Yes, of course.
So maybe for some other lecture.
Yes, why not?
We can think about that. So, and again, thank you very much for your patience, for your
Thank you, Maria and
participation.
Leonor, for telling us all your experience. It was great.
Thank you for your participation. And well, you have our emails.
Let's call it a day. Goodbye.
Goodbye. Thank you.
Goodbye.
Bye. Thank you.
Bye. See you.